Hey everyone, welcome back to the channel. Today we're revisiting a sovereign citizen case that I honestly forgot was even still pending until the court finally wrapped it up. And trust me, the ending was absolutely worth the wait. Not because the case suddenly went in some wild, unexpected direction, but because the judge's reaction to this sovereign citizen's completely unhinged, circular answers is on another level. What unfolds in those final moments is pure courtroom gold. The way this all comes together is better than anything I could have imagined.
On the record, calling 21170-598, Midland Credit Management versus Kevin Hurst. Date and time for pretrial. No appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this trial, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr.
So we attempted to do discovery anyways.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to.
And seriously, what does freeze even mean in this context? Are you having some kind of episode? Because that's honestly the only explanation for thinking that scribbling on the outside of your discovery packet with a neon highlighter somehow makes it invalid. As if writing "I don't accept this" is a magic spell that erases the legal disaster you've already created. It doesn't pause the case. It doesn't cancel reality. And it definitely doesn't save you. All it does is broadcast your confusion directly to the court.
So what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor,
you don't want to accept
I'm not even sure. I do not have any understanding of this is my.
And what exactly did you think was inside the packet you refused to accept? Because rejecting your own discovery might be one of the dumbest moves you can make in a courtroom. All it guarantees is that you walk into trial completely blind. No understanding of the charges, no clue what evidence the state has, nothing. You didn't outsmart the system. You disarmed yourself. You voluntarily stepped into a legal fight without even looking at the weapon pointed straight at you.
With these allegations, I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was, and that I truly owe this debt.
Well, Your Honor, just indicate that we did attach to those.
They already
excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. She cut me off.
You, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst.
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute you.
I don't even understand.
Oh, that part? I believe it completely. In fact, based on everything we've seen so far, I'm not even convinced you could tie your own shoes without turning it into a full-blown emergency. You seem like the type who would get halfway through, lose track of what you're doing, bend down, panic, and somehow end up chewing on your own sock instead. And honestly, after watching the choices you've made in this courtroom, that wouldn't even crack the top 5 most confusing things about you.
Muting Mr. Hurst, and I will let Ms. Strickhart say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickhart, you are responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refuse the packet, because I don't know if they're trying to contract with me.
And trust me when I say this, sovereign citizens are financial black holes. They don't just drain money. They consume logic, common sense, and every dollar unlucky enough to wander too close. No one with even a basic grasp of finances would ever willingly do business with you. In fact, anyone with a functioning brain and a working wallet would sprint in the opposite direction before getting pulled into what you call a belief system.
I know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you.
So yes, he's in the same position she was, just without the 8+ years of law school that might have given him even a slim chance. And that difference matters. A lot. Anyway, that brings us to the end of his first appearance. After all the stubborn posturing and performative resistance, he finally caves and accepts the packet. Reality wins, for now. But don't get comfortable, because next comes his second appearance. And from here on out, it only gets worse for him and a whole lot more entertaining for everyone else.
Question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Strickhart?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. receive and open the package. Because if you do not, request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you, I got a question. Should they have sent me something before they send me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case.
Okay, so she's going to send me a packet and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't interrupt me again. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request for admissions.
He's about to be served a full platter of reality, piled high with steaming nonsense and generously topped with his own terrible decisions. And now we finally reach the moment I've been teasing this entire video. And when I say this part is fun, I don't mean fun for him, not even remotely. I mean fun for the judge. Because what's about to happen is pure courtroom comedy, the kind you couldn't script if you tried.
We are on the record. This is 21-170-598. Linden Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waive none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right. Where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking you first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan court rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the...
7. He's about to be served a full platter of reality, piled high with steaming nonsense and generously topped with his own terrible decisions. And now we finally reach the moment I've been teasing this entire video. And when I say this part is fun, I don't mean fun for him, not even remotely. I mean fun for the judge. Because what's about to happen is pure courtroom comedy, the kind you couldn't script if you tried. 8. Even better, it's one of those rare courtroom moments that somehow gets funnier every time you watch it. Seriously, the more you replay it, the more details you catch, and the better it gets.
The court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? Plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is an admissions by our defendant of the validity of the contract, admission by a defendant that Midland Creditor is a proper party plaintiff. And then we have in request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must, by affidavit or as otherwise provided in this rule, demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under
the judge cuts straight through the nonsense and reduces the entire situation to one simple fact: money was taken, and the work never started. Excuses about vehicle problems don't slow him down for even a second. From the bench, he makes it crystal clear that taking a deposit without doing the job is unacceptable. Then comes the ultimatum: return the $1,500 immediately, or judgment will be entered. The pressure is applied early, authority is firmly established, and the tone in the courtroom shifts to serious almost instantly.
Your name, sir?
Chris Malosh. Good morning, Good morning, Your Honor.
Come on up here, folks. Both of you right out next to the podium there. Tell me your name, ma'am.
Jenny Senior.
Good morning, sir. Your name?
Wayne Senior.
$1,500. Did you start the job yet?
What was happening is I had serious problems with my van.
All right, hang on a second. This seems pretty basic to me. I mean, I'm only going to ask myself one question. 2 questions. Did they give you $1,500 as a down?
They did.
Hang on. And did you start the work like you were supposed to by September 30th? Hang on. if they gave you 1,500 and you didn't start the work, you guys can do one of two things. You can either give them back the 1,500 bucks today, which I'm going to expect you to do, because you wouldn't have spent the money if you didn't earn it yet, or we're going to proceed to a judgment. But you can't take down payments and not do things. I don't want to hear this about your van. Did he communicate to that to you, that he had problems with his van?
Yes.
sir.
All right. So I'm going in chambers. You guys are going to go talk this out for a couple minutes. But it seems to me that if they gave you $1,500, and if you didn't start the work when you're supposed to, they can say, just give me the $1,500, which I'm going to expect you to give back today, right now. Go to the bank and get it. Or you guys can agree, hey, he's going to start by, we understood he had a van problem, the contract was for, and we're going to proceed in accordance with the contractual terms that we agreed upon initially. So that's what I'm going to do. I'm getting off this bench. You guys go talk.
From here, the case escalates quickly. Both sides claim there was an agreement, but the moment the judge digs into the numbers, the story starts falling apart. The defendant insists he never spent the money, then contradicts himself almost immediately. That's when things take a sharp turn with a sudden claim that thousands of dollars were stolen from his bank account. The judge's patience wears thin as the story keeps changing, and the fact that no police report was ever filed becomes a massive red flag.
Chris Milan.
Did you guys resolve it?
Yes.
Yes, sir.
What is the resolution?
So we agreed to Chris's request to pay the in 6 months installment. The total comes up with the court fees of $1,623 divided by 6 months.
Hang on one second.
Sure.
So let's just talk about the figures first.
Yes, sir.
You have $1,500 plus you have $65 in a filing fee.
Yes.
Plus you have $58.25 in a service fee.
Yes, sir.
So that total amounts to $123.25 plus the $1,500. So is that total $1,623.25?
Yes, sir.
Why can't you pay them today?
I couldn't even make rent, Your Honor.
You took their $1,500.
Right.
Listen,
Sorry.
you took their $1,500. You were supposed to start by September 24th or 21st. I mean, you should not have spent that money. It wasn't yours.
I didn't.
What do you mean you didn't? If you didn't hang on.
I'm sorry.
If you didn't spend the money, you'd be able to go get it out of an account right now, wouldn't you?
Yes.
Then you did spend the money.
Can I explain?
I can't wait to hear.
Well, in the meantime, with all the van problems and everything else that we had, when I first started working on her.
Just give me the short version.
Okay. Someone went into the bank account and I lost 2 deposits and whatever money I had. The bank is already trying to work on that.
Somebody went into your bank account?
Yes. So I had to close the bank account. We don't know. It's just all numbers. It was a business account.
Wait a minute. Slow down. Did you make a police report?
No, I just told the bank and filled out their paper.
Slow down. You're telling me somebody went into your bank account and took money out of it?
Yeah.
And the bank didn't reimburse you?
No. I had to fill out.
Slow down. That's a fraud. They can't go into your bank account and start taking out money. Go make a police report today, right now, when you leave.
I didn't know about that.
I want to get this correct. Let me just make sure I understand everything now. You took $1,500, right?
Yes.
You were supposed to start by September 24th, right?
Right.
You didn't start by September 24th, right?
Right.
Now you're telling me somebody went in and took that money out of your account